This audio case is brought to you by Laudio. Walkovszky v. Carlton, 1966. This case involves what appears to be a rather common practice in the taxicab industry of vesting the ownership of a taxi fleet in many corporations, each owning only one or two cabs. The complaint alleges that the plaintiff was severely injured 4 years ago in New York City when he was run down by a taxicab owned by the defendant, N.Y.2d Cab Corporation, and negligently operated at the time by the defendant, Marchese. The individual defendant, Carlton, is claimed to be a stockholder of 10 corporations, including N.Y.2d, each of which has but 2 cabs registered in its name, and it is implied that only the minimum automobile liability insurance required by law, in the amount of $10,000, is carried on any one cab. Although seemingly independent of one another, these corporations are alleged to be, quote, operated as a single entity, unit, and enterprise, end quote, with regard to financing, supplies, repairs, employees, and garaging, and all are named as defendants. The plaintiff asserts that he is also entitled to hold their stockholders personally liable for the damages sought, because the multiple corporate structure constitutes an unlawful attempt, quote, to defraud members of the general public, end quote, who might be injured by the cabs. The defendant Carlton has moved, pursuant to CPLR 3211A7, to dismiss the complaint on the ground that, as to him, it, quote, fails to state a cause of action, end quote. The court at special term granted the motion, but the appellate division, by a divided vote, reversed, holding that a valid cause of action was sufficiently stated. The defendant Carlton appeals to us from the non-final order by leave of the appellate division on a certified question. The law permits the incorporation of a business for the very purpose of enabling its proprietors to escape personal liability, but, manifestly, the privilege is not without its limits. Broadly speaking, the courts will disregard the corporate form, or, to use the accepted terminology, pierce the corporate veil, whenever necessary, quote, to prevent fraud or to achieve equity, end quote. In determining whether liability should be extended to reach assets beyond those belonging to the corporation, we are guided, as Judge Cardozo noted, by general rules of agency. In other words, whenever anyone uses control of the corporation to further his own rather than the corporation's business, he will be liable for the corporation's acts, quote, upon the principle of respondeat superior, applicable even where the agent is a natural person, end quote. Such liability, moreover, extends not only to the corporation's commercial dealings, but to its negligent acts as well. In the Mangan case, the plaintiff was injured as a result of the negligent operation of a cab owned and operated by one of 4 corporations affiliated with the defendant, Terminal. Although the defendant was not a stockholder of any of the operating companies, both the defendant and the operating companies were owned, for the most part, by the same parties. The defendant's name, Terminal, was conspicuously displayed on the sides of all of the taxis used in the enterprise and, in point of fact, the defendant actually serviced, inspected, repaired, and dispatched them. These facts were deemed to provide sufficient cause for piercing the corporate veil of the operating company, the nominal owner of the cab which injured the plaintiff, and holding the defendant liable. The operating companies were simply instrumentalities for carrying on the business of the defendant without imposing upon it financial and other liabilities incident to the actual ownership and operation of the cabs. In the case before us, the plaintiff has explicitly alleged that none of the corporations, quote, had a separate existence of their own, end quote, and, as indicated above, all are named as defendants. However, it is one thing to assert that a corporation is a fragment of a larger corporate combine which actually conducts the business. It is quite another to claim that the corporation is a, quote, dummy, end quote, for its individual stockholders who are in reality carrying on the business in their personal capacities for purely personal rather than corporate ends. Either circumstance would justify treating the corporation as an agent and piercing the corporate veil to reach the principal, but a different result would follow in each case. In the first, only a larger corporate entity would be held financially responsible, while, in the other, the stockholder would be personally liable. Either the stockholder is conducting the business in his individual capacity, or he is not. If he is, he will be liable. If he is not, then it does not matter, insofar as his personal liability is concerned, that the enterprise is actually being carried on by a larger, quote, enterprise entity, end quote. At this stage in the present litigation, we are concerned only with the pleadings, and since CPLR 3014 permits causes of action to be stated, quote, alternatively or hypothetically, end quote, it is possible for the plaintiff to allege both theories as the basis for his demand for judgment. In ascertaining whether he has done so, we must consider the entire pleading, adducing therefrom, quote, whatever can be implied from its statements by fair and reasonable intendment, end quote. Reading the complaint in this case most favorably and liberally, we do not believe that there can be gathered from its averments the allegations required to spell out a valid cause of action against the defendant Carlton. The individual defendant is charged with having, quote, organized, managed, dominated, and controlled, end quote, a fragmented corporate entity, but there are no allegations that he was conducting business in his individual capacity. Had the taxicab fleet been owned by a single corporation, it would be readily apparent that the plaintiff would face formidable barriers in attempting to establish personal liability on the part of the corporation's stockholders. The fact that the fleet ownership had been deliberately split up among many corporations does not ease the plaintiff's burden in that respect. The corporate form may not be disregarded merely because the assets of the corporation, together with the mandatory insurance coverage of the vehicle which struck the plaintiff, are insufficient to assure him the recovery sought. If Carlton were to be held individually liable on those facts alone, the decision would apply equally to the thousands of cabs which are owned by their individual drivers who conduct their businesses through corporations organized pursuant to Section 401 of the Business Corporation Law and carry the minimum insurance required by Subdivision 1, Paragraph A of Section 370 of the Vehicle and Traffic Law. These taxi owner-operators are entitled to form such corporations, and we agree with the court at special term that if the insurance coverage required by statute, quote, is inadequate for the protection of the public, the remedy lies not with the courts, but with the legislature, end quote. It may very well be sound policy to require that certain corporations must take out liability insurance, which will afford adequate compensation to their potential tort victims. However, the responsibility for imposing conditions on the privilege of incorporation has been committed by the Constitution to the legislature, and it may not be fairly implied from any statute that the legislature intended, without the slightest discussion or debate, to require of taxi corporations that they carry automobile liability insurance over and above that mandated by the Vehicle and Traffic Law. This is not to say that it is impossible for a plaintiff to state a valid cause of action against the defendant Carlton. However, the simple fact is that the plaintiff has just not done so here. While the complaint alleges that the separate corporations were undercapitalized and that their assets have been intermingled, it is barren of any sufficiently particularized statements that the defendant Carlton and his associates are actually doing business in their individual capacities, shuttling their personal funds in and out of the corporations, quote, without regard to formality and to suit their immediate convenience, end quote. Such a, quote, perversion of the privilege to do business in a corporate form, end quote, would justify imposing personal liability on the individual stockholders. Nothing of the sort has in fact been charged, and it cannot reasonably or logically be inferred from the happenstance that the business of Sion Cab Corporation may actually be carried on by a larger corporate entity composed of many corporations which, under general principles of agency, would be liable to each other's creditors in contract and in tort. In point of fact, the principle relied upon in the complaint to sustain the imposition of personal liability is not agency, but fraud. Such a cause of action cannot withstand analysis. If it is not fraudulent for the owner-operator of a single cab corporation to take out only the minimum required liability insurance, The enterprise does not become either illicit or fraudulent merely because it consists of many such corporations. The plaintiff's injuries are the same regardless of whether the cab which strikes him is owned by a single corporation or part of a fleet with ownership fragmented among many corporations. Whatever rights he may be able to assert against parties other than the registered owner of the vehicle come into being not because he has been defrauded, but because, under the principle of respondeat superior, he is entitled to hold the whole enterprise responsible for the acts of its agents. In sum, then, the complaint falls short of adequately stating a cause of action against the defendant Carlton in his individual capacity. The order of the appellate division should be reversed, with costs in this court and in the appellate division, the certified question answered in the negative, and the order of the Supreme Court, Richmond County, reinstated, with leave to serve an amended complaint. Dissent. Justice Keating dissenting. The defendant Carlton, the shareholder here sought to be held for the negligence of the driver of a taxicab, was a principal shareholder and organizer of the defendant corporation which owned the taxicab. The corporation was one of 10 organized by the defendant, each containing 2 cabs and each cab having the minimum liability insurance coverage mandated by Section 370 of the Vehicle and Traffic Law. The sole assets of these operating corporations are the vehicles themselves, and they are apparently subject to mortgages. From their inception, these corporations were intentionally undercapitalized for the purpose of avoiding responsibility for acts which were bound to arise as a result of the operation of a large taxi fleet having cars out on the street 24 hours a day and engaged in public transportation. And during the course of the corporation's existence, all income was continually drained out of the corporations for the same purpose. The issue presented by this action is whether the policy of this state, which affords those desiring to engage in a business enterprise the privilege of limited liability through the use of corporate device, is so strong that it will permit that privilege to continue no matter how much it is abused, no matter how irresponsibly the corporation is operated, no matter what the cost to the public. I do not believe that it is. Under the circumstances of this case, the shareholders should all be held individually liable to this plaintiff for the injuries he suffered. At least, the matter should not be disposed of on the pleadings by dismissal of the complaint. Quote, if a corporation is organized and carries on business without substantial capital in such a way that the corporation is likely to have no sufficient assets available to meet its debts, it is inequitable that shareholders should set up such a flimsy organization to escape personal liability. The attempt to do corporate business without providing any sufficient basis of financial responsibility to creditors is an abuse of a separate entity and will be ineffectual to exempt the shareholders from corporate debts. It is coming to be recognized as the policy of law that shareholders should in good faith put at the risk of the business unencumbered capital reasonably adequate for its prospective liabilities. If the capital is illusory or trifling compared with the business to be done and the risks of loss, this is a ground for denying the separate entity privilege. End quote. In Minton v. Cavaney, the Supreme Court of California had occasion to discuss this problem in a negligence case. The corporation of which the defendant was an organizer, director, and officer operated a public swimming pool. One afternoon, the plaintiff's daughter drowned in the pool as a result of the alleged negligence of the corporation. Justice Roger Traynor, speaking for the court, outlined the applicable law in this area. Quote, the figurative terminology, alter ego, and disregard of the corporate entity, he wrote, is generally used to refer to the various situations that are an abuse of the corporate privilege. The equitable owners of a corporation, for example, are personally liable when they treat the assets of the corporation as their own and add or withdraw capital from the corporation at will, when they hold themselves out as being personally liable for the debts of the corporation, or when they provide inadequate capitalization and actively participate in the conduct of corporate affairs. End quote. Examining the facts of the case in light of the legal principles just enumerated, he found that, quote, it was undisputed that there was no attempt to provide adequate capitalization. The corporation never had any substantial assets. It leased the pool that it operated, and the lease was forfeited for failure to pay the rent. Its capital was trifling compared with the business to be done and the risks of loss." End quote. It seems obvious that one of the risks of loss referred to was the possibility of drownings due to the negligence of the corporation, and the defendant's failure to provide such assets or any fund for recovery resulted in his being held personally liable. In Anderson v. Abbott, the defendant shareholders had organized a holding company and transferred to that company shares which they held in various national banks in return for shares in the holding company. The holding company did not have sufficient assets to meet the double liability requirements of the governing federal statutes, which provided that the owners of shares in national banks were personally liable for corporate obligations, quote, "to the extent of the amount of their stock therein, at the par value thereof, in addition to the amount invested in such shares." End quote. The court had found that these transfers were made in good faith, that other defendant shareholders who had purchased shares in the holding company had done so in good faith, and that the organization of such a holding company was entirely legal. Despite this finding, the Supreme Court, speaking through Mr. Justice Douglas, pierced the corporate veil of the holding company and held all the shareholders, even those who had no part in the organization of the corporation, individually responsible for the corporate obligations as mandated by the statute. "Limited liability," he wrote, quote, "is the rule, not the exception, and on that assumption large undertakings are rested, vast enterprises are launched, and huge sums of capital attracted. But there are occasions when the limited liability sought to be obtained through the corporation will be qualified or denied." Mr. Justice Cardozo stated that a surrender of that principle of limited liability would be made when the sacrifice is essential to the end that some accepted public policy may be defended or upheld. The cases of fraud make up part of that exception, but they do not exhaust it. An obvious inadequacy of capital, measured by the nature and magnitude of the corporate undertaking, has frequently been an important factor in cases denying stockholders the defense of limited liability. That rule has been invoked even in absence of a legislative policy which undercapitalization would defeat. It becomes more important in a case such as the present one, where the statutory policy of double liability will be defeated if impecunious bank stockholding companies are allowed to be interposed as non-conductors of liability. It has often been held that the interposition of a corporation will not be allowed to defeat a legislative policy, whether that was the aim or only the result of the arrangement. The courts will not permit themselves to be blinded or deceived by mere forms of law, but will deal with the substance of the transaction involved as if the corporate agency did not exist and as the justice of the case may require. End quote. The policy of this state has always been to provide and facilitate recovery for those injured through the negligence of others. The automobile, by its very nature, is capable of causing severe and costly injuries when not operated in a proper manner. The great increase in the number of automobile accidents, combined with the frequent financial irresponsibility of the individual driving the car, led to the adoption of Section 388 of the Vehicle and Traffic Law, which had the effect of imposing upon the owner of the vehicle the responsibility for its negligent operation. It is upon this very statute that the cause of action against both the corporation and the individual defendant is predicated. In addition, the legislature, still concerned with the financial irresponsibility of those who owned and operated motor vehicles, enacted a statute requiring minimum liability coverage for all owners of automobiles. The important public policy represented by both these statutes is outlined in Section 310 of the Vehicle and Traffic Law. That section provides that, quote, "The legislature is concerned over the rising toll of motor vehicle accidents and the suffering and loss thereby inflicted. The legislature determines that it is a matter of grave concern that motorists shall be financially able to respond in damages for their negligent acts, so that innocent victims of motor vehicle accidents may be recompensed for the injury and financial loss inflicted upon them." End quote. The defendant Carlton claims that, because the minimum amount of insurance required by the statute was obtained, The corporate veil cannot and should not be pierced, despite the fact that the assets of the corporation which owned the cab were, quote, trifling compared with the business to be done and the risks of loss, end quote, which were certain to be encountered. I do not agree. The legislature, in requiring minimum liability insurance of $10,000, no doubt intended to provide at least some small fund for recovery against those individuals and corporations who just did not have and were not able to raise or accumulate assets sufficient to satisfy the claims of those who were injured as a result of their negligence. It certainly could not have intended to shield those individuals who organized corporations with the specific intent of avoiding responsibility to the public, where the operation of the corporate enterprise yielded profits sufficient to purchase additional insurance. Moreover, it is reasonable to assume that the legislature believed that those individuals and corporations having substantial assets would take out insurance far in excess of the minimum in order to protect those assets from depletion. Given the cost of hospital care and treatment and the nature of the injuries sustained in auto collisions, it would be unreasonable to assume that the legislature believed that the minimum provided in the statute would in and of itself be sufficient to recompense, quote, innocent victims of motor vehicle accidents for the injury and financial loss inflicted upon them, end quote. The defendant, however, argues that the failure of the legislature to increase the minimum insurance requirements indicates legislative acquiescence in this scheme to avoid liability to the public. In the absence of a clear legislative statement, approval of a scheme having such serious consequences is not to be so lightly inferred. The defendant contends that the court will be encroaching upon the legislative domain by ignoring the corporate veil and holding the individual shareholder. This argument was answered by Mr. Justice Douglas in Anderson v. Abbott when he wrote that, quote, in the field in which we are presently concerned, judicial power hardly oversteps the bounds when it refuses to lend its aid to a promotional project which would circumvent or undermine a legislative policy. To deny it that function would be to make it impotent in situations where, historically, it has made some of its most notable contributions. If the judicial power is helpless to protect a legislative program from schemes for easy avoidance, then indeed it has become a handy implement of high finance. Judicial interference to cripple or defeat a legislative policy is one thing. Judicial interference with the plans of those whose corporate or other devices would circumvent that policy is quite another. Once the purpose or effect of the scheme is clear, once the legislative policy is plain, we would indeed forsake a great tradition to say we were helpless to fashion the instruments for appropriate relief. End quote. The defendant contends that a decision holding him personally liable would discourage people from engaging in corporate enterprise. What I would merely hold is that a participating shareholder of a corporation vested with a public interest, organized with capital insufficient to meet liabilities which are certain to arise in the ordinary course of the corporation's business, may be held personally responsible for such liabilities. Where corporate income is not sufficient to cover the cost of insurance premiums above the statutory minimum, or where initially adequate finances dwindle under the pressure of competition, bad times, or extraordinary and unexpected liability, obviously the shareholder will not be held liable. The only types of corporate enterprises that will be discouraged as a result of a decision allowing the individual shareholder to be sued will be those such as the one in question, designed solely to abuse the corporate privilege at the expense of the public interest. For these reasons, I would vote to affirm the order of the Appellate Division. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook and subscribe to our YouTube channel.